Okay, we're going to get started, if you don't mind. And I am so happy to see so many familiar faces. And we have such an interesting topic to talk to you guys about. But very quickly, I'll introduce myself. I'm David Warren, chairperson of Bridgeford Trust Company and co-founder. And for so many years, we've had the pleasure of coming into California to work with very large families on concepts like ING and the idea of using modern trust law in a way that you can find asset protection and compelling tax planning and the kinds of things that we're all interested in. And this ING conversation is something we're going to focus on. But before we get there, I wanted to talk a little bit about what we can overall do together in the industry. You know, the idea of what we stand for and what we represent is, in my opinion, very compelling. And to me, it's great to see the familiar faces that are in the room, because over the years, the support of Bridgeford by so many of you has been amazing. And you know, for those of you who don't know, Bridgeford as a rep office is now based in Southern California in Newport Beach. And that's a big move for us, because over the years we realized that working with California families has been so gratifying to us, because as we all can say, and those in the room are actually our California families, there's a need for this type of planning. And the message tonight is that although if there are people in this room that have an ING or have engaged in this type of planning, all is not lost. And there are still workarounds, and there are still things we can do. And there are still aspects of this planning that is really, really important. So here's what we want to accomplish tonight. We're going to get into the conversation about ING just to kind of define it a little bit, although it doesn't apply anymore, but use the principles around ING, and Bill's going to talk to you in particular detail about how all is not lost, as I said a moment ago, and that the objective, as we recall, using ING is tax planning primarily, but also asset protection, because it's built on an asset protection chassis. And so what the hope is by the time we're done tonight is that we see that for California residents, there's still some really compelling planning opportunities around all of this that we used ING for in the first place. And so, you know, from my perspective, having done this for years, because of Bill, who taught this to me, and I'm going to talk about Bill in a minute, the worry is that we think that all is lost for California residents, and it's certainly not. So the theme is to talk about INGs, get into the workarounds. I'm going to talk about other aspects of modern trust law that are still also very important in conjunction, because it isn't just about tax planning, right? It's also about asset protection, and it's also about other aspects of modern trust law that are not available in California. And we're going to talk a little bit about that as well. So I want to introduce Bill Lipkind, and then I'm going to quickly, again, kind of define the concept of ING, but it's so timely that I talk about Bill before I talk about ING, because he taught me what it was. Right around the same time I met Coastal Bridge in Kimberly and the group there. If you Google Bill Lipkind, you'll see that he's probably written the most articles in Trust and Estates magazine on ING. He's an attorney based out of the Northeast, but he's prolific across the country. He took a chance on a very young Bridgeford Trust Company and taught me some really important aspects of how to use modern trust law out of South Dakota, but also Nevada and other top-tier trust jurisdictions. Harvard Law School grad. He's probably one of the most brilliant lawyers I've ever met. And what I love about him is he's not just pushing the envelope because he's trying to represent his clients. He's not ever doing anything nefarious. I said a moment ago, this is not about tax evasion. This is about effective tax planning. None of us are dealing with nefarious clients, and we'll get to this in a minute, but also I think what we're doing collectively is virtuous, and I think what Bill has done is virtuous over the years. He and his firm have had and achieved the most PLRs on ING in the nation. And that's combining all of their law firms and anybody else who's in this space. So I refer to him as the godfather of ING, which means don't piss him off, because he can make you disappear. Now, all joking aside, he's a bona fide expert and has become a mentor to me. And there's no better person, in my opinion, in the industry to talk to you about how to still achieve what you wanted to achieve with your families by using ING in the first place, and the fact that there are still ways to get there. And Bill's going to talk to you about that. So let's just get very quickly, and I'm going to just do a recant or a recap of what the incomplete grantor trust. It still exists in other states, just not here. But remember that the goal was to do what? Avoid paying capital gains for in a high tax state like California on a sale of a low-cost basis asset. So we all know what it was. We all understand the idea that it was an incomplete gift. That's where the PLRs come from. And we understand that in its totality, it created a tremendous opportunity that worked, which is why California didn't like it, right? Billions of dollars in California state laws, probably more than that. More than that, it's a big number already. Families took advantage of this, and California shut it down. New York also shut it down, probably in a less harsh way that Bill's going to talk to you about. But the idea is that it's a concept that is still exciting in other jurisdictions, and we understand the point of it. And I don't need to spend much more time on why we loved it, except to acknowledge my friend who's an asset protection person. It wasn't just a tax play. And it gets to where we're going to go at the other part of the presentation. It was also an asset protection play. Remember, for those of you who have used this, and those of you who may have not used it yet, or understood it as a concept, it's based on, I call it a chassis or a foundation of a domestic asset protection trust, which is defined as a self-settled asset protection trust. And Bill's going to get into that in more detail. So my point is that this whole structure, while probably never going to be able to use again in its current form in California, sorry it's gone, sorry it's dead, we call it the death of Ing. But it's not the death of very, very compelling and sophisticated planning for taxes, asset protection, and privacy, and everything else by using the right trust jurisdiction that has modern trust law. So with that, I'm going to let my good friend Bill take over, and I want to thank you for everything you've done to teach me about all these topics and the support you've given Bridgeford over the years. You are a true expert in this space. So Bill, please take it from here.
David, thank you, and Melissa will observe later that I didn't interrupt you once in the...
I look forward to that happening in the future, though.
It's a particular pleasure to be here this afternoon, this evening. We have a lot of clients in conjunction with Morgan Stanley, so that's familiar to us. We have our Jerry Rival table right here in the middle, and we love Jerry Rival. Kimberly I've known for a long, long time, so it's sort of nice to fly out 3,000 miles and be with a substantial number of people where I feel I'm at home. I'm not dealing with strangers. We're a firm of some 1,100 lawyers. Fortunately, virtually all of them are litigators, so they don't understand what I'm doing, and they'll leave me alone.
No offense to our litigator in the back, though.
No offense, Nick.
It's a real advantage. The tax department, our tax team, is the one place in the firm when we do opinions of counsel. We go through our committee on opinions. The general counsel to the firm, the Office of General Counsel, says, don't wait for me to approve it. I don't understand it anyway. If Lipkind's okay with it, we're okay with it. It's a pleasure to be able to operate a business and not have the bureaucracy interfering. There are a number of things we care about, especially with our California clients. We have 3 offices here. We're in San Francisco, LA, and down San Diego. I have failed for many years to get San Diego to move up to Newport Beach, but I have a daughter in Newport Beach, but so be it. I don't have to tell anyone here how ugly it is to probate a will in California. You want to shoot yourself rather than have to deal with that. And I don't have to tell anyone here how much you hate paying California income taxes, but I challenge any of you to tell me when the governor sent a thank you note when you or any of your clients paid the taxes. So in dealing with trusts, forgetting about avoiding California taxes, I think in terms of wealth preservation, for what we do to go through the stress and aggravation of this life before we go to our just or unjust rewards. You'd sort of like to have what you've done pass on without other people dipping their hands in your pockets. So I'll jokingly, I'm out of the New Jersey office, and I'll jokingly say nobody who can afford my fees would do a New Jersey trust because it just doesn't offer anything of use. What I like about South Dakota, and my two favorite jurisdictions are South Dakota and Nevada. I have some problems with Delaware, or the IRS has some problems they've told me about in Delaware, although they haven't litigated it. And I have here and there people like to make use of Wyoming, and Alaska is just the same thing as Nevada. So you're basically having the two states at the top. I mean, if I have money, what would I really like to do? I'd like to put it someplace where if I die, no estate taxes. I'd like to put it someplace where I can minimize legitimately tax consequences. I'm not going to make a fraudulent conveyance, so I'm going to put it someplace where once I've done, I have the best state protection against creditors deciding they don't love me anymore. In New Jersey, the statute of limitations is that it runs until the creditor has actual knowledge of the transfer. So if you live in New Jersey, if you want to beat your creditor, you send the creditor a registered letter saying, I'm beating you, you're now on notice. I've never had a client do that. And you know, I love my children, but I'm not looking to provide for them and divorce myself from my own assets. So I'd like to have something that accomplishes all the results where I can say, A, I'm a beneficiary, and B, I emotionally feel I'm in control. Now that's before we get to saving state income taxes. In South Dakota, I can be a beneficiary of my own trust. The state, the statute, the courts hate the creditor side. They're there to protect the trust. It's the only state where I had to deal with the regulators on a private trust company, and I was concerned about something, and they said, Mr. Lipkind, don't worry about it. We're here to help you, not to interfere with what you're trying to do. I can't get that out of New York or New Jersey, or God forbid the board in California. So you think about these things. To be a beneficiary, to have I can hire and fire. If I need the money, I can get at the money. These are all reasons to think that way. Now, historically, what we were doing was incomplete gift, non-grantor trusts. Incomplete is a federal gift and estate tax concept. Grantor versus non-grantor is an income tax concept. The two don't always have words that have the same meaning in both contexts. We have about 95 PLRs out of IRS on INGs. They stopped issuing 2 years ago. My favorite senior attorneys in the IRS agree with me that everything we've done is right, but there's some people who think that there's an intellectual, moral inconsistency between having a non-grantor trust and an incomplete gift. So be it. I can't control that. They promised me 2-3 years ago that they're going to come out with new regulations and clean it all up. I said, just assure me this isn't going to be like decanting where in my lifetime we'll never see something. They said, don't worry, Bill. You're going to see it very soon. There will be no hair on my head and I still won't see it. So there we are. New York, several years ago, they did all sorts of marvelous things in New York. They said that an incomplete gift non-grantor trust for federal purposes is now a grantor trust in New York. And some of the workarounds I'll be talking about in a few minutes, which is the fun thing of this afternoon. We've been doing in New York for some time with NARI, a complaint from the state. New York also has the magic that if 5,000 partners sell their partnership interest in an entity that's doing business in New York, but there's only one purchaser, it's going to be deemed an asset sale, not an entity sale. That's conceptually fascinating. There are workarounds for that also, but New York has its unique tax aspects. The New York throwback rule is only for DNI, unlike California, which is we throw back on everything. And the statute that the governor signed on July 10th doesn't do anything to interfere with the throwbacks. So that's always going to be an issue in California. Putting to one side, the rival firm knows very well that there are a variety of workarounds for the throwback, but that hasn't changed. So if you think about one of my favorite stories, lovely lady in Orange County had sold her business for $200 million, and she didn't want to pay 13.8% to California. I said, oh, pay it. The governor will send you a thank you note. She laughed at me. So we did it, and she didn't pay. But she didn't like the throwback rule. So she took her entire family off to Hawaii so she could pull the money out and have no throwback rule. But the volcano erupted, and her house burned down. She said, not a problem. She moved the entire family to Palm Beach, Florida, until the hurricane hit and flooded her out. But she's never paid the throwback on California. So there we are with a lot of people who have assets that may explode in value, and we can't afford, if it's going to sell for $400 million, you can't make a gift. You're not paying 40% over $27 million in gift taxes. So you'd want to do the incomplete non-grantor trust. And what happens? A couple of years ago, the board, having really given up conceptually fighting with us, because we did our first in California in 2012. And in 11 years now, not one penny to the board on any of our clients. You know, the wealth advisors say that prior experience is no guarantee of future results, but it makes you feel better when you go to sleep at night that the board isn't bothering you. So they gave up a couple of years ago, and they proposed to the legislature, oh, go do the New York bill, and we'll put this to bed. It never got out of committee. And then, lo and behold, as a lot of you know, come January of 23 and you're reading Governor Newsom's budget, there it is, but it's in its worst form. When he signed on July 10th, he held up that bill for a few days because we were all wondering, is he going to make it, as it was written, effective back to January 1 of 23, or as of the date he was signing? We had a number of clients, went to church, lit a candle, prayed to God. Notwithstanding, they went to the wrong church, obviously. He signed the bill. So as of January 1, 23, any incomplete non-gift trust done by a California person is going to be treated for California as a grantor trust. Footnote. People say, well, do you think that's constitutional to go back that way? I said, I don't know. There are a number of things that New York has done that I question, but I've never found a client who wants to spend 10 years litigating with the state, a fortune in legal fees, just to test out my theory on why something works or doesn't work. They say, Lipkind, find a workaround. So I leave it to someone else. And think about the mechanics. Somebody's going to say it's unconstitutional. So they're going to file a return for 23. They'll get audited. It'll work its way through the board, up through the courts. We could be 7, 8 years from now to get an answer. And what do you do with your clients between now and then? The answer is you deal with the cards got dealt out, you deal with the hand that was dealt to you, and we move on from there. So I'm not going off on a tangent for unconstitutional. So we have, if you did something in 22 and had whatever you did in 22, you're still protected. You have the throwback rule, but you don't have the new statute. A client, here in Beverly Hills, this involves $200 million as he prayed to God that it would be effective only after the governor signed it, because the closing is scheduled for December. And lo and behold, it got passed. He's now sitting with $200 million. He was sitting with stock worth $200 million in his Alaska trust, contemplating 13.8 to the state of California. And I'm going to tell you in a few moments what we did for him and render an opinion as one of the workarounds. The entire statute, I mean, here it is. We'll forget about that stuff. It's only one page, and believe it or not, half of the page is devoted to an exception. Well, this statute doesn't apply to charitable remainder trusts, but that's something different. They have a provision here that it doesn't apply if you have an incomplete non-grantor trust where the trust says that 90% of the distributable net income is going to go to charity, and you file an election with the board, and it just doesn't apply. What's DNI? I know what DNI is at the federal level. I can't find anything in the California statutes defining the phrase DNI.
Does it say DNI?
Pardon me?
Does it say DNI? Or
It says
does it say
distributable net income.
It does.
That's the word of it. When they talk about incomplete non-grantor trusts, they cross-reference to the Internal Revenue Code. The lawyer's going to say, well, if they cross-reference the Internal Revenue Code for incomplete non-grantor trust, they mean something different for DNI. The problem with that argument, this is how we make money, I guess. The problem with that argument is that in section 17731, subsection A, it says, and I'll read you the entire section, it's marvelous. Subchapter J of Chapter 1 of Subtitle A of the Internal Revenue Code relating to estates, trusts, beneficiaries, and decedents shall apply, except as otherwise provided. There's no otherwise provision, so as far as I'm concerned, there being no otherwise provision, my position is going to be DNI in this statute has the meaning within the Internal Revenue Code. We're going to come back to that. There was an announcement from the board saying, recognizing this exception to 17082, and they say, well, on your 541 form, check either box 11 or 12 as may be applicable. So you say, well, where's the 541 form with boxes 11 and 12? It doesn't exist. Knowing I had to come out here and talk to you people, I say to Adam Bookwalter, one of my partners back in the office, I don't care how long you spend on the phone, because when I tried to reach out to the board, when I explained what these things were, the lady just hung up on me. But you hang on and get a live person. So they say, finally he got a live person who said, yes, it'll be on the 541 for calendar 23, which will probably get out sometime in January. So we're going to put in the back of your mind, if I want to do something to impact 23, I have to make a decision based upon some form they're not going to give us till 24. We'll come back to that. This is a lot of fun. I can't begin to tell you how much fun it is. So we now have this situation where the ING doesn't work in California, and what am I going to do? So we have about 5 workarounds, and the whole point of having you all here and subjecting you to this is to talk about the workarounds. The first one, okay, I got $27,200,000 in credits as of January 1 for gift tax purposes. If the world doesn't come to an end, I lose half of that anyway at the end of 25, And if I made any gifts beforehand, that's coming off first. I may have nothing left. Each and every one of you, other than the client, has said to the clients, use it or lose it. So the first thing you're going to say, we want to siphon off what you got that's most eligible, where you don't want to pay California taxes, for $27 million worth into a completed gift trust. We're talking about, what are we talking about in that trust with Bridgeford? The grantor, or the grantors, it's community property, so husband and wife are both settlors, can hire and fire the trustee. Love David, but I'm not asking my client to marry him. We do these things as directed.
That's an issue for me personally too. So.
We do these things as directed trusts, so we can have a separate trust fiduciary, not living in California, run the money. We can have a protector who can hire and fire people. The gentleman from Loeb will tell you that California lawyers prefer having the protector not domiciled in California either, even though he's not a fiduciary under the terms of the trust or the law or South Dakota law, but who can trust the board to read simple English and agree with it? So that's being protective. I put it into the trust in order to get the federal estate tax results on a completed gift. I have to bar creditors. If I did this in New Jersey, where I cannot have a self-settled spendthrift trust, creditors like Sherman in Atlanta marching to the sea can go right through that trust and get it all out. I have no estate tax savings. We got, before Alaska did their first statute in 97, we got a PLR in 93 on an offshore trust, really the only good one the IRS ever issued. It was out of the Isle of Jersey, where self-settled spendthrift trust in Jersey. And I got the IRS to give me a ruling that under Jersey law, not New Jersey, under Jersey law, since the creditors couldn't get at it, the estate tax people won't get at it either. So in order to achieve the estate tax results for the protection of the widows and the orphans, which is praiseworthy, a marvelous thing to do. We're all here to protect widows and orphans. We don't care about the men. You have to bar creditors or you don't get your tax result. Asset protection is not a purpose. It just happens to be a consequence of what goes on here. At least in my shop, you'll never see us writing about asset protection to clients. You'll see us writing about wealth preservation and what we have to do to get wealth preservation, and we leave it to phone calls to talk about the collateral benefits. So I put my $27 million into a South Dakota trust. I'll live with my daughter in Newport Beach for the moment. I can hire and fire David. I can hire someone from who knows where to be my wealth advisor. If I need money, how do you get money out of a non-grantor trust? You need the consent of an adverse party. 677 of the code. It's right there. What's an adverse party? This is marvelous Congress writing bills. It's defined in 671 and 2. It's somebody who would have a material interest if you took the money out and gave it to the settlor. It's called a beneficiary to me. Most of the rulings you'll see, we have a committee that has to consent. Because the IRS, they gave me 2 rulings where I had a single person. I liked that. My clients loved it also. Then they decided that I would pack the trust with lots of beneficiaries, and my clients can go shopping for one to give the consent, and they wouldn't give me any more rulings on that, although they agreed that if you're confined to the normal things like children and whatever, you have an adverse party. I've never had a problem. Oh, an adverse party. The best adverse party is a minor child. And for the clients who have these 3-month-old, 1-year-old, 3-year-old grandchildren, it's marvelous. How does a 1-year-old grandchild give consent? The answer is, read any of my PLRs. They appoint somebody. We call them a guardian. I like to use words that are nice and fuzzy and sound warm and happy. It's not a state-appointed guardian. It's someone to act as a rep on behalf of that minor during the minority. So if I can appoint my best friend as the guardian for that 1-year-old, for 17 years, I get money out of my completed gift non-grantor trust whenever my friend says okay. We've never had a problem with this. These are all in the private letter rulings. It's just a marvelous way to go. So much of a speech for the first 27 or whatever you have left going into a completed gift trust, because your client can be a beneficiary, can control who's running the money, who the trustee is, and if you and your client think about it, you see to it that there's one or more beneficiaries who are going to be sympathetic to the needs of your client, especially those beneficiaries who don't want to get disinherited if they're not sympathetic.
Let me ask you a quick question on that, because the idea.
You can ask.
Again, just one.
Just one.
So the idea, though, right, is that's why I think this might be of the most relevant solutions, is that often because of the work that you're all doing when you create these or when you advise people on them, is you get valuations that are, I don't say unreasonably low, but are discounted, right? So $27 million is a lot of money. So the thought is, and you can speak to this, isn't it in this aspect of the potential workaround, it comes down in many respects to the valuation, right?
Well, what you're really getting at, David, is that we bend over backwards, that even if no matter how much of an interest in the company the client owns, we only want to transfer a minority interest so we can get a minority interest discount.
Absolutely.
That's a whole other discussion about Wandry clauses to protect yourself if the IRS disagrees with the valuation. But just for purposes of today, 27 may very well be equal to 40.
Right.
If
That's my point.
You're dealing with the whole enchilada.
That's my point.
But that's a very true statement. You want to do this and get your minority interest. My law firm has a favorite appraiser here. Anything west of the Mississippi, there's an outfit down in Orange County we use because A, they do good work, B, they're smart, C, they understand us, D, they get there fast, and E, we can always pick their brain quickly to get a quick sense of where we're going before we go down a path.
And F, they tell them the number that Bill Lipkind tells them to tell them.
I never tell the appraiser what number I want.
Just kidding.
All right, now the next one.
What's their name? He wants to know their
Right,
name.
so much for the completed
We'll
gift.
We'll get it to you.
What we've been doing for years in New York is our Q-tips, qualified terminal interest property. It's under the Internal Revenue Code. So we're doing something where we're saluting the flag. That always pleases me that we accomplish our strategy and salute the flag at the same time. What is a Q-tip? A Q-tip is a completed gift by one spouse for the benefit of by one person for the benefit of their spouse. It must say that all income, this is fiduciary income, not taxable income, must go to the beneficiary spouse. It must say that no one can get a penny out of this thing throughout the lifetime of the beneficiary spouse, regardless of whether the marriage continues. And it's in the beneficiary spouse's estate. You don't have to give the beneficiary spouse any part of the principal. But there's a provision in the regs that says I can take that trust and put it into two parts. A grantor trust portion, which is the income portion, and a non-grantor portion. And that's what we do. So within the language of our trust, we're saying, I was just deciding which example to use. That way I don't have to try to remember as I speak. I have a client here in Beverly Hills who, I mentioned this, who expected to get $200 million, and we'll get it in December. And there he's sitting with his Alaska trust, and Governor Newsom signs the bill. The first thing we did is we did a decant of the trust so that the trustee could give each of the husband and wife general powers of appointment. We then had them exercise their power. They waived their community property rights. The husband does a Q-tip for the wife does a Q-tip for the husband. We vary some things. One's with Bridgeford to make our variants, the other one's in Nevada, but I have the 2 Q-tips. In doing that, we have already rendered our opinion to them. The things you have to be concerned about when you do this is the states that you're using. I can give you assurance on South Dakota that there's no state statute. If I'm going to say all income to the spouse, isn't South Dakota law going to siphon off corpus, which is what I don't want, to call that income? The answer is no. Terry has given us a signed opinion on that. And the other trust we did out of Alaska. I have an Alaska opinion, so you have to look at that. This is obviously the board hasn't seen this. This is a completed gift. The 17082. Even the board can't get around the fact that it only affects incomplete gift trusts. A Q-tip is a completed gift trust. Now, if your client is single and not married, you can't do a Q-tip. If your client says, I don't know if I'm getting divorced next year, Q-tips are not a good idea. But where you have a stable relationship, to me, after the completed gift non-grantor trust, doing the Q-tip where the corpus, the principal, is the non-grantor trust. Within that, we've made that division. I have a regulation on it, no problem with the opinion, and I think that's the easiest way to do things. So I'm very strong on that. Once we get past that, things get a little bit more interesting. Unfortunately, you wind up getting the call from the client. My investment banker just sent out all the books, and I expect to have a letter of intent on Monday, and what do we do to save taxes? You don't get it that, what can I do to save taxes, and I don't think I want to sell for 3 years. One of the things you want to think about, and in my universe, I'll tell clients I couldn't care less whether you ever do anything I suggest. Where my ego goes is I want people, if they don't do something, they should know what they're not doing as opposed to not doing what they don't know. So what I'm about to say is that I just want you to know about this. Whether you do it or not, I don't care. If I create a non-grantor trust and I sell a closely held asset, very long-term installment note, I'm not getting rid of the California tax. Well, maybe I do a couple of these things. I'm dealing with minority interest. I'm pushing my appraisal as low as I can go. I'm pushing the problem off. We'll let inflation and whatever take its track. If once I've sold it to that non-grantor trust, if that non-grantor trust sits with it for 2 years, that's the cross reference to 453E, the anti-rushing provision in there. Then you go resell, you get a step up in basis. If you sell within the 2 years in the related person trust, the whole tax thing goes back to the settlor. So that's something to put on the table for the client. If you're not in a rush, why don't we just do this now? Because if we make this long-term sale to the completed gift non-grantor trust, when you get around to selling, we're home free. We're out of 17082. An ounce of prevention versus a pound of cure. I don't have to preach on that. That's number 3. Then you, staying on, I'm saving the most fun to the last one, which isn't on this page here. Private placement variable life. For those of you who aren't familiar with it, life insurance is marvelous. Ask your local agent, why should I buy a cash value policy, Mr. Agent? Well, Mr. Lipkind, all the cash value grows income tax free, and you can borrow from it income tax free. And when you die, your children will get it income tax free, and you can put it into the trust what's out of your estate. Free, 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 free. Well, people said, you know, having the back office of the insurance company run my money is no fun. We got to do better than that. So they came up with universal life, so we earn more. But still the back office. A universal life policy is a security for SEC purposes, hence private placement. The private placement has a lot of, variable life insurance has a lot of technical requirements. It also has a doctrine called owner control, where it's sort of like when I had brown hair, which was a few years ago. One of the things, I'll never forget my criminal law course. It was Alan Dershowitz, his first year of teaching. He had just come off his clerkship with Justice Goldberg. And Bobby Goldberg was in our section. And we spent almost the entire year discussing whether pornography is what that is and how the criminal law should deal with it. But you basically had judges saying, I can't define it, but when I see it, I know it. Owner control. Facts and circumstances. It's premised on a 1940 Supreme Court decision, but it's a an owner control problem. We get involved with options and stuff like that. But the point for this afternoon is that if I have a potential of something that's very big and the first few things just don't work, here's another idea. Well, how do you implement the idea? I get my favorite appraiser to give me an appraisal on a minority interest in the company. I want the numbers on the option. I want my insurance company to assure me they have enough pure death benefit so I can live with the explosion in value. All these things we have to do, but it's still something to put on the table that's there. And it's better than an ing because you're getting rid of federal taxes as well.
Yeah,
as
if I could jump
state.
in on that. So we hold a lot of PPLI internationally and domestically, and you know it's been around for a long time. It goes into my mind of the book of, you know, it's not nefarious, and although some senators have tried to challenge it, the reality is when we go back to the beginning of what we talked about, why we were doing ings in the first place, tax savings, asset protection, privacy, and the ability to not lose control, subject to the owner control issues that Bill mentioned. So, you know, this is a very real workaround that should be looked at that accomplishes very much or more than what the ing did in California, right?
I mean, there's a risk factor to it because of owner control, but that's a matter of fully articulating the risk factor to the client making a business decision whether the benefit is worth the risk. So be it. Next slide. Yes, D&I. Okay. So we have this charitable exception. This is the most fun. And I'm saying I have a particular client. Two brothers, they're here in LA, own a business where my appraiser says, well, I think the business will sell for next year for around 400 million, but the best I can do on a discount right now is 300 because the books are out there and whatever. And I say, well, they're both single, they're not married. 13 million as a numerator, and if you take 300, half of that is 150. 150 is the denominator. It's less than 10% for each of them. I'm not sneezing at saving 13.8% on 13 million, but it doesn't solve the whole problem. Well, what about private placement, Lipkind? You just spent all that time raving about it. Say, yeah, but if I'm starting at 300, my upside is 400, and I have all the economics to get in there, it's just not worth it. This is something that we have recommended to the client. If I read this, I know you're there. It's just where I'm standing and you're hiding behind the pillar. But if I go back and I reread my statute, if 90% of D&I is going to go to charity, I can have an incomplete non-grantor trust. Well, that's marvelous. If D&I is defined under the Internal Revenue Code, what are we talking about? Rental income from real estate? Dividends? Cash? We're certainly not talking capital gains. Oh, I hate to do this to you. To go back to that Q-tip for a moment, what if there's no cash to give the spouse? All you have to do is put in the trust that the spouse has the right to require the trustee to make it productive of income. So that's no problem if there's no cash coming on the grantor portion. But coming back up to this thing. So I'm saying to these guys, well, if we put, let's say we put $150 million worth into one of these things. There's no income while it's just sitting there. Come next March, you sell, now I have $150 million cash. The wealth advisor is Kimberly's firm. So we say, well, can you think of a way to invest $150 million and minimize ordinary income and dividends? Look at her, nod her head up and down. Yes, she can think of a way. I said, okay. Well, I have an internal decanting provision. My internal decanting provisions are more flexible than Nevada or the state statutes. They're really modeled on my thinking when I was doing my offshore trusts. And before there was any state decanting statute, we worked out a mechanism to try to get to the same result and not have it look too ugly to a judge. But the IRS has seen this. They have all my PLRs. It's my internal decanting. So can I do a trust that gives 90% of the D&I, if there is any, to charity? I have my decanting provision. So if I do the closing in 24, I do what? Decant in 25? I let it sit for a year, decant in 26 to something altogether different. And at the end of the day, I've just not paid California taxes. I mean, my goodness. I have to file the Form 541. Is it just going to check a box? Are they going to ask for a copy of the trust? I don't know. I don't think so. Are they going to tell me what I have to put in the trust, or more importantly, what I cannot put in the trust? All my flexibility? I don't know. Assuming I just check the box, because they don't know either. They don't know what I'm up to. If I get that done in 23, we can run off the trust in the next couple of weeks. I'll just stick this stuff in there. Maybe they hear enough about this. People ask me, are you going to write an article? No, I'm not going to write an article. What am I going to do, give a blueprint to the board? So let's assume that in 25, 6, or 7, they wake up and they come out with rules or regulations blowing it out. I can assure you that the clients I'm doing it for this year are going to be happy puppies, and maybe for next year also. But what's the downside? This is marvelous. The downside is that your trust doesn't qualify for what they want, and you're going to pay the tax. We have already ruled out the other strategies. So there's no downside. So I enjoy chit-chatting with my friends at Brown and Strays a lot because they're a good tax firm down in Orange County. And, well, Sean, you know, we're going to do it and see what happens. And, you know, we'll just see what happens because there's no downside to the client. So I mention this to you all that I think that you have to, I haven't gotten to subchapter S yet. You mention that, but you tell people, we don't know whether the board will eventually do something to whatever, but I don't see the downside in doing it if you're prepared to pay your taxes otherwise, yes.
I was just going to say, I know you had a hard time with me, but I have had more than one conversation, like 2 over the years with people at the FTB who believe that capital gains are always included in DNI.
If capital gains what?
Are always included in DNI, and have had to tell them that is absolutely not the case. So I think, you know, you may have an opportunity.
Well, but I have that statute I read to you
I
where
know, I absolutely
the legislature
understand.
said if we don't say it's not the code, then you follow the code.
The FTB
Smell.
doesn't understand what DNI
No, we know the board doesn't understand. but what I say to the board, here's your statute, go tell the court the statute's unconstitutional.
I understand, but I'm just saying.
Yeah, no, I agree with you.
Whatever reason.
I agree.
They think it is, and they're wrong.
That's
They
right.
have been wrong for a very long time.
Which is why the statute is so sloppily
It's
written.
also why the throwback tax is such a.
But what the heck? If there's no downside in trying for it, life is, you know, if you don't swing the bat, you never hit the ball. So that's my point. Now, contemplate for a moment, what happens when you put a subchapter S stock into a non-grantor trust? To qualify it, the trust to be a stockholder, you got to do an ESBT election. But the code says if you do an ESBT election, there's no DNI. Does that mean that if I put my $1 billion of cash and marketable securities into a subchapter S, shove it into an incomplete non-grantor, shove it into one of these charitable trusts, I got no DNI, I got nothing to give to charity? I don't know. I don't know if I have enough testosterone to go the route with that one. But the ambiguity caused by the sloppy language of not telling us what DNI means when we have that, God bless Sacramento, that underlying statute that says it is what it is, I think that's there. So I think that pretty much that sums up the workarounds our team has come on the California thing. People will smirk and say, well, the net result of what Newsom did is you now have a whole bunch of stuff to talk to existing clients. Spent a lot of time on the phone with Jerry Reibel on one of his leading clients and what to do. And, you know, it's just generating more work for lawyers. That's fine. That's still not criminal in the present administration. And there we are.
So all's not lost, right? Would we agree to that? I mean, there are strategies that can be employed to take these existing INGs and make them perform and accomplish what it is we did in the first place. And Bill, thank you for going through those. And I know there's a lot of people analyzing it, but you even take it further, right? Because we've been talking about a very specific problem that Bill has been focusing on solving, which is to save capital gains on the sale of a low-cost basis stock. Now we're going to talk about, though, why it continues to be even more important now, more than ever perhaps, of selecting a proper trust jurisdiction. Could be Nevada, could be South Dakota. Bill has some issues with Delaware. It doesn't matter. We know, though, what? It's probably not California. Can we agree with that? for the following reasons, and we're going to end on this note. We're going to kind of go through and remember, in addition to the state taxation issues that we've talked about, there's also a cool little case that came out of the Supreme Court called Kasner, which talks about this idea that a state like California cannot tax undistributed income that remains in trust. That's a pretty big deal, right, in California, and is avoided by just what? Selecting proper trust jurisdiction, which is not California. You know, my job here tonight isn't to attack California, but they've created the rules. And I said at the beginning, we're just players, aren't we, at the end of the day? And so if they're going to create an environment that we need to figure out how to deal with to best serve our clients, that's what we're doing. So in addition to everything that Bill's been talking about, we can't forget about Kasner. We've already talked about Ing. There's also community yeah, please. Yeah.
On Kasner, you have to have something. I mean, Walt Disney would have somebody with a magic wand and pixie dust to do this. We need nexus between the trust and the state seeking to impose jurisdiction. If you take states like Connecticut or Illinois, which have these statutes that saying if one of our citizens creates a trust, then come hell or high water, we're going to tax it no matter what. When you read Kasner, that shouldn't work. If you read what the states have said, they've said, well, the beneficiaries can make use of our state to protect their interests. So you contemplate, if you have clients who live outside of California in some state that has one of those ugly statutes, I do a South Dakota trust, and I provide in the trust that whether it's a beneficiary or a creditor, if anybody wants to say boo about the trust, they gotta go to South Dakota if they can figure out where it is. At that point, I've deprived Illinois. I had this whole battle with them, and the Lynn decision in Illinois declaring the use of that statute unconstitutional wasn't broad enough to cover this. There's nothing an Illinois court can do to protect anyone. So where is the nexus if 20 years ago somebody set up a trust and Illinois courts can't do anything to protect it? I haven't had Illinois or Maryland, which has a similar ugly statute, argue with my clients where we've taken that position that when there's no ability of the local court, the mere fact that one of their domiciliaries set up the trust under the Kasner out there. So this isn't just for states like New York and New Jersey and California that don't have that statute, but for any of you, if you have clients who are outside of one of these other ugly states, we can still do the same thing. Kasner helps us.
So jurisdiction matters, right? That's the point. Jurisdiction matters. We all have, the dynasty trust is an old story, but it's still something that is and cannot be forgotten about. I mean, South Dakota was the first state in the United States to abolish the rule against perpetuities. So we can't forget about the ability to avoid a state tax forever by using a dynasty trust. And Bill and I were talking earlier, could that be attacked at some point? Maybe. But again, it comes back to the jurisdiction selection. So the theme, all is not lost here. We talked about domestic asset protection trusts already. My friend's an asset protection person now. You understand that in the United States, they followed suit with some of the offshore jurisdictions. For a myriad of reasons, the United States has become an offshore, a privacy haven, an asset protection haven, in some cases a tax haven. Nobody likes the word haven, but we still use it. The reality is these domestic asset protection trusts have been challenged. Where they failed is what? Somebody want to throw out the phrase? Why have they failed if they ever do fail? Fraudulent conveyance. If there's not a fraudulent conveyance, we don't have a problem. There's not a single case in the United States that has pierced an asset protection trust. In South Dakota, Nevada, Delaware, Alaska, anywhere, there's now 18 or 20 different states that have them. So this intellectual debate...
Can I interrupt you again?
Just one second. This intellectual debate that you hear at a heckling, well, maybe asset protection doesn't work in the United States because of conflicts of laws or whatever. Well, there's a case right now that exists out of California that talks about the fact that actually this does work here in the United States. Yes, please.
restatement of conflict says that a U.S. citizen can form a trust in any jurisdiction, and their domicile state should respect it, except if what they've done is contrary to the public policy of their domicile state. So for 15 years, we've wondered, if I live in California, which doesn't allow self-settled, and I set up a trust in a state that allows self-settled, is the concept of self-settlement such a significant factor that it could invoke that exception to the general rule? I'm unaware of any case in the United States where a court has said that. We've worried about this for 15 years, but where this California, that's a different issue. That's a different issue than if California says it's a fraudulent conveyance. Does South Dakota have to salute and agree under full faith and credit, or can they say that California can't determine what works or doesn't work under our courts? Yes.
Don't you have more risk if you have real property in another
Everybody hear the question?
jurisdiction? Yeah, I mean, clearly have more risk.
Well,
You
you
have like a
well, you have the
California house.
we have all those bankruptcy cases where you,
No, I'm not talking about like fraudulent conveyance or necessarily.
Yeah, no, you're talking about
creditors.
in rem
I'm
jurisdiction.
just talking about
Yeah.
the South Dakota trust, if you have a big property in Malibu in it, if California decides,
You're not-
I mean, you just shouldn't do that.
yeah, well,
No,
you have,
it's
you have a
easy
problem
pushing
with
it.
your Malibu property.
Yeah.
First of all, if you rent it to anyone, it's source income.
course.
So you're stuck, even if it doesn't have anything to do with incomplete gift or completed gift trust. And then secondly, the board is very likely to say that where your corporation's a mere holding company and all it does is holding on to South Dakota, we're going to,
No, I'm talking more about the asset protection element. If
Well-
I'm a beneficiary and I've settled it and I buy a big Malibu property in it, then that seems to me to be a lot more risky.
Well, maybe more, I wouldn't say risk. I understand what you're saying. I would say risky or more subject to being
Or
assailed.
subject to California
Yeah,
courts,
yeah,
'cause
yeah.
they're gonna say,
But to Bill's
"It's our
point,
jurisdiction."
No,
well,
and
no,
I-
clearly a California court can say whatever it wants under California real estate,
Right.
but that's, I'm not aware of any
There's
case
one case
where
about
a
trust.
beneficiary said, you know, disregard the trust because the real estate's here. I live in California, so you can disregard the trust, and, you know, I want to get.
Beneficiary's not gonna say that, but a creditor's gonna say it.
Well,
And
that-
there's one case about an Isle of Man trust, but not.
so
about
I can tell you, I
South
can't
Dakota
tell you the
trust.
name. I'm going to agree with you. I can't tell you the
You
name.
you had a very famous, a few years ago, bankruptcy case where somebody up there, was it Oregon
Oh, yeah,
or
that
Washington?
one, yeah,
And they thought they'd shove it all into an Alaska trust, and that just wasn't getting any place. You also have the 10-year clawback under the
Yeah.
bankruptcy
Right.
statute.
So we're looking at this issue right now. We have exactly the fact pattern you just said, and the property happens to be in Malibu. And we're having this issue right now, this question. And the question is kind of come down to exactly what you said. But Bill said something earlier that I love. You swing the bat to hit the ball, right? And if you don't swing, you don't hit. What is asset protection really? See you, Kimberly. Thank you for being here. Take care. Thank you. What is asset protection really? Is it really a complete barrier, how many angels can dance on the head of a pin kind of question? Or is it really more of a deterrent? Right? Is it, in my mind, and I would love your thoughts. Please comment.
Kind of both.
Okay.
Think about California. California's going to bend over backwards to make sure you don't defeat a creditor's rights. They don't really care what the other state's doing, especially if the property is here.
Right.
I agree.
That's just the way it is.
If you have a South Dakota trust and you have California real estate and the judge is not sympathetic with the setup of the trust, since the judge can get his hands on the California real estate, he doesn't have to, he can just order whatever he wants to order, and there isn't anything that South Dakota can really do.
Right. No, absolutely.
I
Right,
agree.
Absolutely. But again, it's the deterrence question. I mean, we can talk about what the conclusion may or may not be, but sometimes it's just the block that's in place that keeps plaintiff's attorney from spending $100,000 in fees, right?
I was just talking about, like, in terms of giving advice.
Yeah, no, I'm
What
with
are
you
the
completely.
risks, and when would you want to use something versus not? Well, maybe not if you're gonna buy a huge property in it.
Understood.
Yeah, but
Trying to do
you-
something else with it.
Understood.
Might be safer.
You get into another issue. We have a red line in what we do, that we never mix personal use property with investment property. So for the client who sets up one of these trusts, and I have this lovely lady in Colorado setting up a trust. Now she wants to go buy a home in California where she'll live for 4 years. And I'm saying, California may not tax you, but is that a dividend? I mean, what is that? And just to really make it fun, she says, well, I need a car to drive back and forth. Let the trust do that also. At some point, the greed factor has to cause you to say, if you treat this like your pocketbook, the courts may treat it that way also. So on the Malibu property, if that's a personal use property, that does not belong in the same trust with investment property, because even if you don't have a creditor, you have the feds who are saying, well, what's going on here? You're paying fair rent, and there's no such thing as fair rent. It's whatever the auditor says it is. So I wouldn't be happy to have that Malibu property in a trust with other assets.
No, and I
for all
agree
those other
completely.
reasons.
I agree with what you're saying completely. And it'd be interesting to see how the conclusion is, because we Bridgeford are in the middle of fighting this out. We're not subjected to the jurisdiction as Bridgeford or the trust company, but it'll be an interesting point. And I actually do agree with your conclusion. My point, though, is that regardless of where the conclusion comes, when there's the obstacle, sometimes that's the answer, right, in our world. Just very quickly as we wind up, I mean, going back to the jurisdiction selection being so important, I mean, privacy goes hand in hand with asset protection and also the tax plan that we're doing and everything else. So when you're looking at these jurisdiction selections, you're looking at what is privacy, what is secrecy. We make that distinction. There are certain states in the United States that have the most powerful privacy provisions. South Dakota, most of you probably already know this, has the most powerful privacy provisions in the country. That's not my opinion, that's not Bill's opinion, that's the opinion of Trust and Estates magazine, that's the opinion of people much smarter than myself, and there's a couple different aspects to it. But what I want to play around with, because we want to end on a high note always in the next 2 hours. But what we want to do is talk about something that we've...
Actually, I have a question about privacy.
Sure, please.
You look, I don't know, you're going to laugh. It's the Corporate Transparency Act, which is national. It's not a state issue.
Maybe the courts rule it unconstitutional and we don't have that burden on our practices, but go ahead.
Well, my concern is the privacy.
Absolutely.
Because it's got if a trust owns.
Yeah, but that's stuff, but that information is, I'll say it straight, it's going to the feds. And we know that what gets sent to the feds never gets leaked out. Unless you're in New York, where there's now a New York statute,
Yes.
and then California will imitate that. So
Yes.
all of a sudden, all of our assets, wherever owned, is available for predators.
For predators, and they'll find it on the dark web. So
So your question's
The rest of the world already has it.
Yeah, but your question's a great one, because it's a Corporate Transparency Act question, which everybody's talking about, everybody's doing a seminar and a webinar about, and I'm actually already tired of talking about it and it hasn't even gone live yet. I don't mean that in a pejorative way, but your question's a good one, and let's make the distinction, because we're talking about activity at the trust level. Corporate Transparency Act doesn't impact trust reporting.
okay.
And I think, right, Bill, that's an
Not yet.
important, not yet, it may. So for those of
Do
you
you
who
know how many LLCs that my firm has set up in the last 50 years?
a lot?
Yes. The idea of going into going into the electronics to pull each and every one out and get the information that they want, albeit we have all of calendar 24, it's easier to deal with this thing, starting for new things, filing. And it has to be, since that things will get hacked in and it'll be public, it'll be available for a fee to anyone who wants to know. So,
No, but your question is a fair one, and I do want to draw the distinction, because, and that's why I say what we're talking about privacy is at the trust level, that's at the entity level, and in
But
terms of the reporting of it, though.
yeah, but what I want to talk about privacy, our trusts in South Dakota provide, and this is consistent with South Dakota law, that while the settlor is living, the trustee will not disclose what assets are in there without the settlor's consent. So a child writes and says, you know, I need money for a new Ferrari, send it to me. What's in there? Child's spouse's attorney writes and wants to know what's there because they live in Massachusetts and they want to get a piece of the action on the on that. And the trustee is going to say, well, thank you very much, but under the terms of the trust, we need the grantor's consent. So even with the Privacy Act, when you're identifying who the people are, you don't know whether there's $100 there or $100 million there.
Yeah.
So,
That's a great distinction.
and I think that if you stop to think about how many LLCs exist in the United States and are created, that it just arbitrarily, you need good computers to go through there and look for certain names, and that may or may not tell you, it won't tell you how much is
I don't
there.
even believe we're going to have the infrastructure to handle it, to be honest. I mean, I don't mean to be, you know, doomsday,
No, I
but
don't think
I mean, it's too much information. It's too much data. It's just too much to gather, and even to police it, right? Everybody's worried about the onerous penalties for not doing this. I don't even know they even have the IRS doesn't have the man and woman power to handle what they're doing, let alone deal with the Corporate Transparency Act. So I mean, let's talk about the practical realities of this thing. It's really going to go live January? I don't even know if they can handle it at this point. I mean, I don't know what your thoughts are, but it's too much information.
We solved it very simply in our firm.
No, I mean the government.
No,
but, yeah.
I'm going to tell you with a straight face. As chair of the department, I told Karen Swan, who's a very brilliant lawyer in our firm, you're in charge of this. Make it work.
You're a good delegator, Bill. You're a very good delegator. Okay, so let's before we were able to have some drinks and wrap up here. I mean, bring us back to how we began. Conversation just isn't about Ings. It's about those of us who are advisors in this room giving the best advice to clients. Raises this question for all of us in the rooms: the accountants, the attorneys, the trust people. You know, at what point do these concepts become mandatory to talk about with clients? You know, there's a case out of Massachusetts Supreme Court that says there could be a fiduciary duty to decant a trust out of a bad trust jurisdiction, which I would argue is California, into a more favorable trust jurisdiction like South Dakota or Nevada. And where I've become and we've become kind of interested, and I want to get feedback as we wrap this up, is, you know, I said it earlier, you know, this is virtuous work. None of us are doing anything nefarious for bad clients. The litigator, my friend the litigator, knows he can everything we've talked about tonight, you can defend. Absolutely, because we're not breaking any laws. We're using the laws in the best interest of our clients. So if we have a duty to act in the best interest of our clients, then isn't it true at that point that we're supposed to talk about the options to go to a South Dakota or Nevada or Delaware or in Alaska relative to Ings or no Ings, or whether that works, or asset protection or privacy and all that sort of thing? And I've come to the conclusion, I think Bill would agree, I think we absolutely do, and I think that's, and if some lawyer in California says, no, you're fine in California, no, you're really not okay in California, and there's a whole myriad of comments out of the Uniform Probate Code, which I understand California hasn't adopted, but there's a restatement of thirds, and there's comments to the restatement of thirds, and there's a whole myriad of aspects of things that raise this question.
Well, we in South Dakota don't like restatement third for what it says about credit, the benefit of credit.
Well, that part we don't pay attention to. So what I'm saying is, you know, as we wrap this up, I mean, the larger theme is not just Ings. It's about doing the best that we can for our clients and using the most compelling strategies that are available. And we've come to believe, and it's a scary word to throw out in a room full of people like you all, but I mean, when could it or when does it become a malpractice issue when you don't say, hey, you know, if you just go to Nevada right around the corner or South Dakota, your trust can live forever and you never pay estate tax? That's measurable, right? Of course it is. You know, the solutions, the workarounds that Bill talked about very eloquently. If that's not talked about with a client to solve the Ing problem that now exists, I don't know, you can figure that out. Just dollars and cents, you can do the math and figure out where the decision was wrong. So on that note, I want to thank you all for being here. The familiar faces is very gratifying to us at Bridgeford, because again, we've been coming here for years as a young trust company, and we love the support and the work that we do with you, and we can't thank you enough, which has propelled us to actually have, as I said, a presence in Orange County. I want to thank one of my mentors, Bill Lipkind, for sharing his brilliance. I think you would all agree that he is brilliant. And no, but any thoughts, comments? You could tell Bill he's wrong, and he'll be happy to hear that. Yeah. Oh, you were going to say something.
Actually, I was going to ask, I'm not so sure if it's really related to the ING. Have you heard of the recent case regarding taxpayers challenging IRS for taxing income from flow through from?
Yeah, well, we're waiting for the Supreme Court to deal with that. Here in California, if the Supreme Court said you cannot impose an income tax on unrealized income, that would be the end of the wealth tax in California, which is floated around. Yeah, but the wealth tax that has floated around but never has yet to see the light of a governor's signature wouldn't apply to the non-grantor, to the completed gift non-grantor trust and some of these other things. That was a workaround for that also. But that's been quiet. So we're going to have to wait and see what the Supreme Court does on that.
Because my thought is if they win this case, it's going to have big impact on the ING. So essentially, if you don't take money out, you are not able to tax.
No, I don't think that case will have any impact on the non-grantor. The feds are getting their pound of flesh, whether you have a completed gift or an incomplete gift. The feds have no skin in the game on that one. It's strictly a state court matter on the taxation. And I don't think that the throwback rule would ever be violative of saying you can't tax except when money is realized. California has not sought, on the ING thing, what California did is what New York did. They didn't say that we're going to tax you on money you don't have. We're just going to treat this as a grantor trust. And under a grantor trust, the Internal Revenue Code has said many times, this is tax invisible. It's as if there is no trust and it's all in the hands of the grantor. So I don't think that case, even if it saves you on the offshore stuff, is going to be any balm for the ING.
That's a good point. I think I want to mention, and it's just more of a statement to kind of congratulate all of you in this room, and it's sincere. You know, our industry in recent years, including the asset protection work that we do for clients, has been somewhat attacked, right? Like somehow we're bad people because we're helping wealthy people follow the rules and save on taxes, have asset protection, and find privacy and the kinds of things that you did for your family. I don't think we should be embarrassed of that, despite what happened in the Pandora Papers and all these various data leaks. And I think that we should be proud of what we do for our clients. I don't think we should hide from it. I think our clients are entitled to privacy, asset protection, and prudent tax planning. And I think we should be proud of what we're doing for our clients. And I'm actually becoming tired of defending what we do, because I think we're these families are entitled to it because we're just following the rules. And last thing I want to say again is thank you to Melissa Roberson, who organized this whole event, our marketing director, and again, thank you to all of you.